Thank you very much. So we're very happy to have you with us. As we are happy to have with us Mateo Aboy, who's our next speaker. He is currently visiting professor at the University of Cambridge, where he conducts research as a visiting fellow of Wolfson College and research scholar at the Center for IP Information Law, CeBIL, and the Center for Law, Medicine, and Life Sciences, LML. He is also tenured full professor of electrical engineering in EERE department at the Oregon Institute of Technology, Oregon Tech. You are also holding several patents, and you are developing your own advanced algorithms to analyze data. And this is really impressive, and I'm very happy that you will talk about it today. And that you are part of CeBIL, and you're also visiting professor at CeBIL and a special advisor.
Thank you, thank you. Okay, so let's get started. Testing, it works, right? Okay, so I'm Mateo Aboy. I'm doing this talk with my hat from the LML. This is work that was done with Kathy, that is here in the audience, as well as John. And I'm going to be talking about empirical patent studies. So in terms of objectives, I have 2 or 3 objectives. At one level, I'm going to report on the results of a particular empirical study analyzing the impact of Myriad. Okay, that's some relevant for some of the studies that we are doing here. But perhaps more importantly, I'm going to use those results as a case study to illustrate the type of empirical patent research that we are able to do in order to conduct evidence-based IP research. And so in terms of evidence-based IP research or evidence-based patent studies, what do I mean by that? Well, think about the impact of a legal or a regulatory change. And if you're thinking about patents, you could be talking about other IP rights, but in patents, I like to divide those at several levels. One is, what are the broad level effects? And you can think of that, if you will, as 2 landscapes studies, before and after. The next thing is, well, what happens at the claim level? How are the claims changing? Glenn, for instance, mentioned in precision medicine, perhaps, the claims are changing that they are going to be too narrow or not eligible with neural networks, black spot medicine, etc. Is that true? If you go one level lower, well, what about prosecution? What are the prosecution strategies? And when there is a change in the law or in the regulation, what are the wide impacts? Are there any ripple effects, any secondary effects? And so with that, what type of patent studies have we been conducting? We have been conducting studies in 3 main areas. Number 1, what happened after the US Supreme Court decision in Myriad that affects products of nature. Number 2, what happened after Mayo that affects diagnosis. And number 3, what happens after Alice that affects abstract ideas, computer-related inventions, but of course, they also accept biotech. And so those that you see there are check, study 1, study 2, and then B3 are the ones I want to talk a little bit about today at a surface level, a first-order introduction. So I give you a sample of what happens at the broad level, for instance, after Myriad. I study directed to claim-level analysis, and then we will move to Mayo and talk about a prosecution study. So that's the agenda for today. So for study A1, impacts of Myriad on gene patents. These are the sort of questions that we can provide answers that are empirical based. Number 1, prior to Myriad or right after Myriad, some commentators expected that Myriad was going to have a high impact beyond isolated DNA in biotechnology in general. Is that true or not? And so on and so forth. So let me go over those. Not to stop too much on the methodology. For a broad study, of course, you need to do a landscape before and after. Details of this study were published in Nature Biotech last year, Myriad's impact on gene patents. So let me go and touch on some of the highlights. Number 1, did Myriad result in a reduction of gene-related patents in general, beyond isolated DNA? And number 2, what is the proportion of gene-related patents that are already in the public domain? And so since prediction is very difficult, and Neil Bohr said prediction is very difficult, especially if it is about the future, I would like some participation from the audience here. So this is the patent register on general gene-related patents from 1998 to 2005. If you look at that graph, and in 2005 there were an influential Nature Biotech article by Michael Hopkins saying the end of an era. They are going down. What do you think? If you think that they went down from 2005 to 2012, show me like this with your hand down, thumb down. If you think that they went down. If you think that they stay the same, show me a 2. Or if you think that they went up, show me a 3. Please participate, check it out. Same, down, down, up, the same. Okay, so let's see the data. Let's be empirical here. Let's look at it. Actually, they went up. And they went up even more than predicted, there by the line. And so we arrived to 2012. And this is when Myriad happened. And everybody's speculating, oh, if Myriad is decided in such a way that isolated DNA is not patentable from a subject matter legible standpoint, that's going to be very problematic, not only for isolated DNA, but in general. So how many of you think that it went down, the same, or up after Myriad beyond isolated DNA, but gene-related? I'm talking about patents with claims, with sequence IDs, etc. Show me your thumbs. Some up, down, down, you see? So you have subject matter experts, and we have been looking at this, and there was really, reasonable minds were differing, and this was conjecture, right? So it looks like 82% here, 81.2% thought it was going to go down. I'm just half kidding. But this is what actually happened. Let's see. 3 years after Myriad, it didn't go down. If anything, it actually continued going up. Okay? So this is in broad level impact, looking at the data. Let's look at survival rates. It's very interesting to think, though, when you look at the number of patents that were granted and how many of them survive versus how many of them are in the public domain already. You will expect a 20-year term. But you see that even around 10 years ago, around 50% are already in the public domain. Why 10 years and not 20 years? What's going on? Perhaps we need to look deeper. So let's go here. Was the Myriad decision really necessary? Are there any potential side effects? And any trends on isolated gene patent activity over the last 20 years? So now I'm narrowing. This is not gene-related, but only the patents that were affected by Myriad. They have claims directed to isolated DNA. What do you think it happened from 2005 to 2012? How many of you think went down? Please participate, don't be just like engineering students. Down, up, a couple of you up. So this is very interesting. Look at, oh, that was a hint. Do you think it's going to go up or down? Up, down, the same, up. Actually, they went significantly down. Isolated DNA. Huge issue prior to Myriad, right? Huge issue. These are a big problem. But it turns out that they are going down prior to Myriad. What do you think it happened after Myriad? Continue going down, went up? Isolated DNA? They went down. But the interesting thing is that the trajectory was exactly the same. If you realize, pre-Myriad and post-Myriad, or prior to Myriad, these patents were already not being granted. This is quite remarkable because you have potential decision that is changing perhaps the law, perhaps creating a lot of uncertainty, and is not doing anything. And other potential side effects. Look at the relationship between small and large entities, pre and post-Myriad. So do you see any potential negative side effect? What's happening to small entities post-Myriad? These are companies with less than 500 employees as defined by the CFR. So what we are seeing is that post-Myriad, you have almost no small companies getting anything that is gene-related. These patents are much more difficult to prosecute. I'll talk a little bit more in the prosecution study. So are there any indications that the patent system was already self-correcting prior to Myriad? Meaning this was seen as a big issue. And what we see is that isolated gene-related patents And what you see here is both in the US and Europe. This is the patent register. They were going down already, and these are, in general, this is when you look at actually by award date. What is more interesting is that when you look at priority date, this is actually what was happening. The reason why 50% of the patents were in the public domain, not 20 years from the priority date, but in 10 years or less from the priority date, it was that the standard of novelty and non-obviousness was raising the bar of patentability, so it was becoming increasingly difficult already to get an isolated DNA patent. So remember, Myriad decided this on subject matter eligibility on a problem that perhaps, because the priority had already peaked in 1999, this was not an issue anymore. Any patents that were awarded related to isolated DNA, the term may have been only 3 years or 4 years. So that's an interesting point. And this is what you see, by priority, what's going on both in Europe and the US. Okay? So the priority had already peaked. What do I mean by that? The companies that wanted to get an isolated DNA-related patent needed to claim priority to an earlier application and give up term of those patents. So any patents that you could get related to isolated DNA had a much shorter term. Does that make sense? As short as 5 years. Of course, we checked also citation analysis, what are the patents that are most cited, forward and backward citations, and we are able to do these sort of results and answer empirically these sort of questions, right? So what happened to the broad landscape of biotechnology, biomarkers, as well as if there are any side effects. Not going to spend too much time, but at least in this slide, though, what this data seems to suggest, and this is not totally conclusive, is that even if the US Supreme Court decision in Myriad had been the opposite, meaning that isolated DNA is patent eligible, it will not have made a difference in 2012 because the patent system had self-corrected. Novelty and non-obviousness was preventing those patents from being awarded anyway. Now, if that was a decision 15 years earlier, it will be very significant. Does that make sense? Surprisingly, though, although there were a lot of amicus briefs to the US Supreme Court, nobody actually looked at how many patents are out there, what's going on with these patents, is this really an issue? So this is what empirical patent studies can offer. So that was broad impacts, an oversimplification, and a first-order introduction. Let's talk now about claim-level analysis. So it's another paper that was published last year in Nature Biotechnology. After Myriad, what makes a gene patent claim markedly different from Nature? And so this is an example of a claim-level study, meaning there is a decision, a change in the law. Again, this could be a change in regulations, this could be anything, an impact. And we are trying to determine how are the patent claims changing, because patent claims can then go back to business models, to incentives, etc. We heard, for instance, in precision medicine, that now is perhaps more difficult to get patent claims directed to black box medicine because of Alice and Mayo. So let's go here and look at a study like this. This required us doing a search. First was automated, but then we had to do manual analysis in order to look at the prosecution histories and look at the claims before and after. I'm only giving you the highlights. So what happens after Myriad? 79.2% of the patents containing isolated DNA claims were abandoned, or all the claims related to isolated DNA were canceled. It's an important result because there were commentators that stated that the Myriad decision was too narrow and perhaps it was possible to draft around. We didn't see that effect post-Myriad initially. Only 18.6% were successfully amending. And then what we did was, in those cases where you started with a patent with isolated DNA, what type of amendment was possible to transform ineligible subject matter into eligible subject matter and a typology of those amendments. And so that also may be important in some of the previous studies, right, where we are doing landscapes for personalized medicine, orphan drugs, antibiotics, etc. How are the claims changing? Last one, 5 minutes? Okay, good. So since we have 5 minutes, I'll touch on Mayo. So Myriad is directed to products of nature. Mayo is directed to diagnosis. And so anytime that you have a correlation, Mayo is going to be quite significant. And anytime that you have something involving big data, personalized medicine, a neural network, or anything like that, Alice is going to be very significant. And so just to illustrate the same type of studies can be done is Mayo, before and after, what's happening, who are the patent owners that are getting these patents. How are the claims changing? How do you make something that is ineligible under Mayo eligible, and the same thing for Alice? So let's start with that. These are some of the research questions. Number one, so you have a decision, Mayo. Are the patent examiners use it in order to issue 101 rejections? 2, are the applicants using it? 3, what is the prosecution timeline after a decision like this? And 4, well, are you able to look at prosecution strategies? So what do? If in a broad study you do a search of the patent register for granted patents, or a claim study you do a search on claims and how they go before to after, in prosecution you need to look at the correspondence, the office actions within a patent office. And so in this case we look at all the correspondence in the USPTO that had a Mayo rejection. And so here you have, we analyze around 38,000 documents. So are the examiners using Mayo to issue rejections? You bet. There are many decisions that they are never used by a patent examiner, but Mayo is not one of them, or Alice is not one of them. So 38,000 patent documents citing Mayo. Also, applicants are responding with legal arguments based on Mayo. And we have now statistics of what has been allowed, what has been abandoned, what is still pending. A lot of studies pending, but we have 9K applications that have been allowed. And this is a very important data set to see, well, where is the threshold of subject matter eligibility in the USPTO now? So allowance prosecution statistics, 4,218 cases. And then there we can say, well, if you are in this domain and you are a small company, for instance, how many requests for continuing examinations are you expected? How many, what is the timeline? So you should be prepared after Mayo and Alice to prosecute these applications perhaps for 6 years. Okay? And this is one of the reasons why small companies may not be able to do that. And so you see a lot of prosecution statistics, like 6,000 cases abandoned, a proportion of which may be for lack of resources. You see here subject matter eligibility in biotech. So you look at ART unit, or Tech Center 1600 Biotechnology and Organic Chemistry, there used to be relatively few subject matter eligibility rejections. That's the 101, 35 USC 101 in the US. And so you see there before, 11.2% pre-Mayo, and now across the board, 57.2 rejections. So are examiners really using this to justify the rejections? Yes. Is it affecting biotechnology? You bet. We have analyzed what are the classes more affected, what are the applicants more affected, who are able to prosecute this to allowance, and it's very interesting that are large companies with quite a lot of resources. So I have 1 minute left. Let me just move in here to empirical patent studies to relate it to the previous studies. So most of us are familiar with landscape studies, where we look at patent activity per year, patent owners, classes, class evolution, etc. The next level is to look at those, but for an impact. There is a regulatory change, a legal change, what happens at the broad level, what happens at the claim level, what happens at the prosecution level, what are the side effects, and then we can go one step forward and use also the machine learning and artificial intelligence to help us do this type of empirical research, such as, well, giving a patent what are the most similar patents, and, for instance, giving a patent portfolio, how many of those are valid or predicted to be valid. Let me stop here. Thank you.
Thank you very much. Thank you, Mateo. And you can imagine, considering the algorithms you used and also the discussions that we already had, how much we're looking forward to working with you and to also, go into this empirical studies using also the data from CARP-X, for example, to the extent that we're allowed to use it. And we also, are starting to acquire really interesting data that we can bite our teeth into.
Thank you.
So this will be great. So thank you very much. And I think, unless there are any questions from the audience concerning maybe the algorithm that he uses or something. Yes?
My name is Elodie. I'm a researcher, and I think the methodology is beautiful. I'm not trained in that area at all, but I was just wondering how long did it take you to design the study, and how many people were involved? That's my first question. And the second question, would you have come up with another story? Should you have used a purely qualitative approach by interviewing stakeholders? Because that's, from my understanding, mainly research that is mainly quantitative based, using data analytics. But do you think you would have come with another story?
Yeah. So to answer the first question, this work was conducted at the LML at the University of Cambridge, with, as I mentioned, Kathy, John, myself, and Christina, with also Matt, a research associate. So this is the size of the team, and it's a multidisciplinary team. Some legally trained, science trained, engineering trained, able to do big data analytics, right? And create new algorithms for patent analytics and be able to code. So the Myriad study took approximately 1 year. In 1 year, we were able to do both. The broad level study, broad impact of Myriad, as well as the claim level impact. Over that period of time, we also generated the data for the major study, as well as ALICE, although we have not published those. So that's a little bit of the timeline, assuming that you have the right team with the right set of expertise to be able to do that. It becomes more difficult when you need to do, beyond what can be automated, when you need to do expert review of claims, like the claim study takes longer, simply because you have now 1,000 patterns that you need to review claims, and you want to go before and after, and you want to create a claim typology. You cannot automate that, right? We, in addition to looking at the patent register and looking at empirical what happens at the broad level, claim level, prosecution, wide impacts, we also conduct interviews. So John is having a study really to complement. So for instance, you say, okay, who are the firms that actually were able to get an isolated DNA patent changed from isolated DNA to something else that is subject matter eligible, the ones that were successful? Well, let's talk to them. And all these others that actually abandoned the patents, and perhaps they were able, perhaps they were subject matter eligible, it's interesting to know what happened to them. Did they lose the investment? Because that's also an impact in biomedical innovation, right? As you increase subject matter eligibility requirements, it may be that only large firms are able to handle these 3 rounds of prosecution. And what is the effect to the innovation landscape? So interviews are important to complement what the data is telling you on a first instance, right? But the objective was, okay, so you have commentators initially saying, well, Myriad is going to have a huge impact. Myriad is not going to have a huge impact. Well, let's look at the data. This is a huge problem of patents. Maybe there are not so many. Maybe this was a problem that was self-correcting. It's going to be very easy to draft around. It turns out that we did not find a single claim which was successfully drafted around at the same level of the scope. So, if you find it, then it's good to follow up.
May I just have a final question before we go to the coffee break? I think a tricky thing is also that the effect of Myriad is really, you can't always see it isolated. It's a combination of Alice, Prometheus, and Myriad, right?
Correct.
So how do you tackle that you have a combined effect?
That's a great question. So over here, we are now conducting this study A4, which is Myriad impacts beyond isolated DNA, right? So you think it's an isolated DNA, it's been used all throughout, and over there, when we search, we looked at office actions that cited Myriad, but then we also looked at, did they also cite Mayo? Did he also cite Alice? And then we are analyzing to the combined effect. For biomedical innovation, of course, the three of them are key. And it depends on what the study. So precision medicine, it is really Alice and Mayo. Things more on biologics or nucleic acids is going to be Myriad. Depending on whether you have products or methods, method claims are going to be affected by Mayo, and if you automate them to get over Mayo, and so it's not a law of nature, then you have an Alice problem. So the combined effect is huge.
There were more questions, but I think we leave them for the panel debate. I'm sorry that I shipped in, but so please keep your questions. We will have a panel debate when you can ask Mateo.